Hello everyone and welcome to the briefing session on funding and disclosure for the state election 2026. Before we begin today, I would like to make an acknowledgement of country. We acknowledge the land that we meet on today is the traditional land for the Kaurna people and that we respect their spiritual relationship with their country. We also acknowledge the Kaurna people as the custodians of the Adelaide region and that their cultural and heritage beliefs are still as important to living Kaurna people today. We also pay respects to the cultural authority of Aboriginal people visiting or attending from other areas of South Australia. Before we start, I'd like to draw your attention to the disclaimers on the screen and ask that you take note of these. The next slide deals with the key dates for funding and disclosure. You will note that this started on the 1st of July 2025 and moved across to July 2026. On the slide, you will see some of the more important dates, but this does not contain all of the dates that are required under the legislation. Of importance on this slide is the advance funding, which has commenced now, and you must apply for before polling day on the 21st of March. Public funding in South Australia has undertaken some major reforms. Some of these key reforms include the regulation of donations and loans, the introduction of advance funding, the requirement to register state campaign account, increased criteria on party registration, and changes to disclosure and compliance requirements. The next few slides explain these changes in terms of how they interact with the previous Act. I don't intend to go individually through these changes, and these slides will be available at the conclusion of this briefing. We will now look at funding. Electoral funding, or also known as public funding, is an integral part of the electoral reforms. The new public funding arrangements have been introduced to support both registered political parties and eligible candidates. The funding can be broadly divided into two categories, this being advance funding, which occurs before the election, and public funding, which occurs after the election. Advance funding is paid in two payments, Payment A and Payment B. Payment A can be applied for from now up until polling day, and this payment will be made as soon as is reasonably practicable upon the completion of a valid form. To apply for advance funding, you are required to lodge a 130PF certificate, which can be provided to you upon application on email. Payment A is 60% of your notional amount, or 2,500, depending if you're recontesting or not recontesting. Payment B is paid after the issue of the writ, or your nomination date if this is later. If you've already applied for and been paid a Payment A, then this is paid automatically and is made as soon as reasonably practicable after the writ is issued. This is 20% of your notional amount, or 2,500. You may apply for both payments A and B at the same time if your application is after the issue of the writ. If you do apply for advance funding, it's important to note that the Electoral Commissioner may, in certain circumstances, require repayment. These include if you do not contest the election, if you are a registered political party and you cease to operate, or if there's no entitlement to funding in respect of votes given at that election. If an entitled registered political party lodges a 130 PF and at the time of nominations there is a difference in the number of candidates nominated for that election, the agent must pay to the Electoral Commissioner any excess. If the difference is positive, the Electoral Commissioner must pay the agent any remaining funds for each additional candidate. You would have seen from previous slides we spoke about notional amounts. On the screen now is the basic formula. However, this often changes depending on the category of the applicant, and this can be explained more in the regulations. Sections 130PA and 130PC of the Electoral Act describe how these calculations are made. The 130PF certificate, as previously alluded to, can be lodged before polling day. Once this is lodged, you cannot withdraw this certificate. If the certificate is lodged by an entitled registered political party, group or candidate, they must state the number of districts in the House of Assembly and or the number of candidates in the Legislative Council. You must also indicate whether you're electing to be recontesting. Certain applicants must also attach with the 130PF a list of relevant electors. If you miss the relevant deadline to lodge a certificate, this being polling day, you will not be eligible to receive advance funding, but you may be eligible under 130Q for reimbursement of your political expenditure. It's important to note that whilst you may submit a 130PF and be paid advance funding, this is not your nomination. We will use the list of nominators, if applicable, for the nomination process, but you must still complete the nomination form before the close of nominations. Failure to do so will result in recovery of any advance funding paid, and more importantly, you will not be able to run in the state 2026 election. We'll now cover public funding, which is the funding paid after the conclusion of the election. Public funding is payable to candidates who gain at least 4% of eligible votes in the House of Assembly or 2% in the Legislative Council, or if the candidate is elected. This is payable within 120 days after polling day and upon the lodgement of a capped expenditure return. The capped expenditure return must also contain evidence of your political expenditure. In terms of the funding payable, this is dependent on your category. Parliamentary parties will receive $5.50, non-parliamentaries $6 for the first 10% and $5.50 per vote afterwards. Independent members of Parliament $8.50 and unendorsed candidates $9 for the first 10% and $8.50 thereafter. This is based on your actual expenditure up to your expenditure cap, and any amount payable will be minus your advanced funding. Moving on to donations. This is a new area for 2026 as per the recent reforms. The Act now defines what an electoral donation or loan is. This being a donation or loan that is made for the benefit of a Member of Parliament, candidate, or third party, and is used or intended to be used solely or substantially for state electoral purposes. An electoral donation or loan that is made to an associated entity is taken to be a donation to or for the benefit of the party to which the entity is associated to. The intent of this provision is not to capture incidental items which may be considered donations but are not electoral donations. An example of this may be where a candidate or a member of parliament is gifted a drink bowl or a meal of low value. Donations and loans to certain parties and candidates are now unlawful. This includes donations and loans made to registered political parties, including associated entities, members of parliament, groups and candidates, and third parties. However, there are some exceptions to this. The exceptions during the prohibited period allow for donations and loans to be made to regulated designated participants who have elected not to be recontesting. However, these are capped. There is an individual cap of $5,000, which means that you may not receive or a person may not make donations more than $5,000 to an entity. There is also a general cap, which changes and is the amount equal to your applicable expenditure cap. The Act also allows some other exceptions. These include amounts paid into a federal account for federal purposes, and also allows candidates to pay or contribute to their election campaign. In the House of Assembly, an endorsed candidate may contribute to their election campaign up to 50% of their expenditure cap, and an unendorsed candidate may contribute up to their relevant cap. In the Legislative Council, a candidate may contribute up to $100,000. When contributing to your own campaign, it is important to note that all money must be paid into the state campaign account held by the agent or candidate, and if you exceed the caps, you may be liable to repay twice the excess to the Crown. You may also commit an offence pursuant to 130 ZZE of the Act. We will now move on to disclosures. Before exploring disclosures any further, it is important to understand what a disclosure is. So a disclosure return is the reporting of financial information as required under Part 13A of the Electoral Act. Public disclosures enhance public confidence and ensure the integrity and transparency of a political campaign and any funding payable. As part of ECSA's role, we will conduct audits and compliance activities to ensure the integrity of disclosure information, and non-compliance carries significant penalties. Disclosures are relevant to agents of registered political parties, candidates or their agents, groups of candidates, and donors. Disclosures are required within the prescribed lodgement times and must be lodged with ECSA via email within 5 days of the end of the first 30 days of the designated period, which has already occurred and many of you have complied with. Moving forward, for candidates, it's every 7 days until 30 days after polling day, and a final return must be lodged within 5 days of the end of the designated period. For registered political parties, many of the prescribed lodgement times remain the same, with the exception of the 7 days. As a political party, you are only required to submit returns every 14 days. Disclosures are required to have audit certificates. During the election period, you're only required to provide 2 bulk certificates. The first is lodged 7 days before polling day, and the remainder is lodged on the final return due date. If your disclosure return is nil, or if the compliance costs are unreasonable, you may apply to the Electoral Commissioner for a waiver. It is important to note that where an audit certificate is required, a return is not regarded as lodged until that audit certificate accompanies it. We spoke briefly about capped expenditure. During the election period, political expenditure is subject to strict expenditure caps. These limits are designed to promote fairness, prevent disproportionate influence, and ensure transparency in campaign financing. The capped expenditure period has already begun and will run until the 20th of April 2026. Expenditure caps differ depending on the participant type. On the screen now, you can see the various participant types and what their expenditure cap is for the 2026 election. For endorsed candidates in the House of Assembly districts, the expenditure caps are determined by an agreement between the candidate and the party's agent. This agreement must be no more than 100,000, be formally notified to the Electoral Commissioner at least 8 days prior to polling day. Once notified, the agreed amount cannot be changed, and if no agreement is received, then the amount defaults to 40,000. The Electoral Commissioner will not publish the agreement until after the capped expenditure period concludes. When a candidate is endorsed by a registered political party, both the candidate and the party must ensure that political expenditure is properly attributed and does not exceed the applicable cap. Party agents must monitor the spending to avoid breaching the candidate's cap. Candidates must ensure that expenditure relates only to their own electoral district, and expenditure is considered district related if it is communicated to electors in that district and not mainly to those that reside outside. There are strict penalties for exceeding your expenditure cap. Breaching the expenditure cap during the capped expenditure period can result in serious consequences. If a person exceeds their cap, the Crown may recover an amount equal to 10 times the excess from the agent responsible. This recovery is in addition to any other penalties or offences under the Electoral Act. It is important that agents actively monitor and manage expenditure to avoid any liability. Importantly, please note an election may be declared void on the grounds of a breach of Section 130ZA, which is the capped expenditure provisions, if the Court of Disputed Returns finds, on the balance of probabilities, that the result of the election was affected by the breach of this cap. In terms of our regulatory approach, the Electoral Commissioner has the legislative responsibility to ensure that participants comply with the provisions contained within the Electoral Act. We will monitor compliance, investigate and take enforcement action to respond to unlawful conduct. ECSA uses a constructive compliance approach where engagement and education is prioritised. If education fails to address non-compliance, the Electoral Commissioner may investigate and to take proportionate action. Our principles include to engage constructively, provide opportunity for stakeholders to explain conduct or the error, allow stakeholders to be heard before decisions are made, and to communicate outcomes in a timely manner. Some of the offences in the Electoral Act include when a person knows that they are conducting an unlawful act or omission, if a person ought to know that they were conducting an unlawful act or omission, schemes to circumvent prohibition on donations and expenditure. You'll see from this slide that there are strict penalties, including imprisonment from 2 to 10 years and fines from 10,000 to 50,000. This now concludes our information session and briefing on funding and disclosure for the state 2026 election. Should you have any questions that have not been answered, then please contact us on exa.fad@sa.gov.au.